Okay, stay with me here, because this is one of those stories where every detail matters. At 6:47 in the morning on Friday, February 6th, the four United States Marshals showed up at a mansion on Star Island in Miami, Florida. They knocked on the door. They presented a federal court order, and when they left, they had Ivanka Trump's passport. Now, that fact alone, a former senior White House advisor, having her travel documents seized by federal agents, that alone would be extraordinary. But here's the thing. That's not even the most significant part of this story. Not even close. What happened in the 48 hours before that passport seizure? That's where this gets really interesting. And what's coming in the next 72 hours? That's where it gets dangerous for a lot of people who thought they were safe. I spent the weekend doing something that I suspect very few people in cable news actually did. I read the filings. All 187 pages of them. 3 times through. And I need to tell you, what's in those documents goes so far beyond what the headlines have been reporting that it almost feels like we're talking about two different cases. The case in the headlines? Former Trump advisor faces financial charges. The case in the documents? That's something else entirely. We're talking about $127 million. 23 shell companies. Wire transfers to Cyprus, the Cayman Islands, and a company in Nevada that has no employees, no office, and no income. We're talking about 89 individual cash withdrawals, every single one of them, for $9,500. And we're talking about Melania Trump walking into a federal building in Washington, D.C. on Thursday, sitting down with prosecutors for 2 hours, answering 147 questions under oath, and then walking out. The next morning, marshals showed up at Ivanka's door. The sequence of those events is not a coincidence. Let me give you the context, because context matters. Ivanka Trump served as a senior advisor in her father's White House. She currently runs multiple business entities registered in 6 different states. According to these newly filed court documents, and I want to be very clear that I'm quoting from legal filings here, not offering my own analysis, federal investigators allege that those business entities were used to launder money through a network of limited liability companies. That's not my characterization. That's what the filing says. Page 43. Direct quote. The defendant facilitated the transfer of funds from Trump Organization subsidiary accounts to a Delaware-registered entity with no discernible legitimate business purpose. Money was moved. Where it ended up doesn't make sense based on any legitimate business records. And the person whose signature is on the wire transfer authorizations? Ivanka Trump. Here's how we got here, and this timeline matters because it tells you how prosecutors built this case. Months ago, a grand jury convened in Manhattan. Subpoenas went out. Ivanka's lawyers immediately started fighting those document requests. Executive privilege. Legal immunity. Every possible objection. Weeks ago, a federal judge rejected every single one of those arguments and ordered full compliance. Days ago, Melania Trump walked into that federal building. Thursday, Melania testifies for 2 hours. Friday morning, marshals arrive. Friday afternoon, sealed court exhibits are made public. Friday evening, the judge orders Ivanka to surrender all electronic devices used for business communications since 2021. That is not prosecutors scrambling. That is a coordinated operation. Every step was planned. Every move was sequenced. Now, let me walk you through what the documents actually show, because this is where the case either stands up or falls apart. Page 89 of the filing. Between March 2023 and November 2024, Ivanka Trump's signature appears on 31 separate authorizations for wire transfers, totaling $84.7 million. Where did that money go? A holding company in Cyprus, a subsidiary in the Cayman Islands, and a company registered in Nevada that, I need you to hear this, has no employees, no income, and no physical office. That's documented on pages 91 through 103. You can read it yourself. It's in the public record now. But here's where it gets worse. Buried on page 147, there's an exhibit labeled Exhibit F. Almost nobody is talking about this, and I genuinely don't understand why, because this might be the most damning part of the entire filing. According to verified financial records, Ivanka Trump personally withdrew $3.2 million in cash equivalents over a 14-month period. 89 separate transactions. Every single one of them, every single one, for exactly $9,500. Now, why does that number matter? Federal law requires banks to automatically report any cash transaction of $10,000 or more to the Treasury Department. It's called a currency transaction report. The idea is to help catch money laundering, tax evasion, that sort of thing. If you keep your transactions under $10,000, no automatic report. What prosecutors are alleging, and this is the legal term for it, is structuring. Deliberately breaking up transactions to stay under the reporting threshold. And here's the key point. Structuring is a federal crime. It doesn't matter if the underlying money is legitimate. The act of deliberately avoiding the reporting requirement is itself illegal. And prosecutors say they can prove she knew exactly what she was doing. Which brings us to Melania. According to the court documents, page 156, paragraph 14, the witness identified as MT told investigators, under oath, that she was present for multiple conversations in which Ivanka discussed keeping transactions below reporting limits. Direct quote from the filing. The defendant instructed others to keep it under 10. Always under 10. That's not an accountant saying that. That's not a business associate. That's the former First Lady of the United States testifying under oath about her stepdaughter. She answered 147 questions. She took one break. She did not invoke her Fifth Amendment right to remain silent. Not once. And on page 162, prosecutors make an argument that I think is going to be central to this entire case. They argue that Ivanka Trump had specific knowledge of federal financial reporting requirements because of the position she held in the White House. They're not just saying she did this. They're saying she knew she was doing it, and she knew why it was wrong. Now, here's where I need to be fair, because the defense has arguments too, and some of them aren't frivolous. Ivanka's lawyers filed their response on Thursday. 47 pages of business records, contracts with foreign companies, revenue statements. Their argument is that those offshore entities had legitimate business purposes, international licensing deals, brand management contracts. Money moved because business operations moved. Nothing suspicious. They also directly attacked Melania's credibility. Page 23 of their motion. The witness designated as MT has significant personal and financial motivations to provide testimony favorable to the prosecution. In plain English, she has her own reasons for cooperating, and those reasons might have nothing to do with the truth. Family relationships are complicated. Everyone watching this story knows that. Conservative critics have made additional arguments. The timing is suspicious. The investigation intensified right before election season. Using Melania's testimony against Ivanka, they say, is manipulative. And the structuring charge itself isn't straightforward. Prosecutors have to prove specific intent to avoid reporting requirements, not just a pattern. Alan Dershowitz, the Harvard law professor, said it directly. Structuring charges require proof of intent to evade. Patterns alone don't establish criminal culpability. Even Jonathan Turley, who is nobody's idea of a liberal, raised questions about using family testimony and the timing of the charges. These aren't nothing arguments. They're real legal issues that will matter at trial. But here's what I keep coming back to. The judge looked at this evidence and decided that Ivanka Trump is a flight risk. That's why the passport was seized. That's why bail was set at $15 million. That's why she's wearing a GPS monitor right now. Judges don't do that casually. They don't guess. They make assessments based on evidence. Former U.S. Attorney Barbara McQuaid called the sequence of events extraordinary. She said this wasn't prosecutors reacting to developments, this was a carefully planned strategy executed step by step. Renato Mariotti, former federal prosecutor with 15 years at the Department of Justice, said taking someone's passport at this stage means prosecutors have substantial evidence and genuine concern about flight risk. They don't take that step unless they're confident. Daniel Goldman, former assistant U.S. attorney, said Melania's testimony is the linchpin of the entire case. Family witnesses are incredibly powerful and incredibly rare. Even Tim Parlator, who previously served as an attorney for Donald Trump himself, admitted that if the structuring pattern is as well documented as the filing suggests, the defense has considerable work ahead. When people on both sides of the political spectrum are saying this is serious, it's serious. Let me tell you exactly how Friday unfolded, because the speed of this matters. 6:47 a.m. Marshals arrive at the Star Island residence. 7:23 a.m. Passport is surrendered. By then, Ivanka's lawyer was already on the phone with the duty judge, requesting an emergency order to stop the seizure. That request was denied at 8:12 a.m. The court found sufficient evidence of flight risk based on international business connections and access to private aircraft. Friday afternoon, bail hearing. $15 million secured. Friday evening, GPS monitoring attached before she left the courthouse. And then the judge did something that almost got lost in the chaos of everything else. She ordered Ivanka's legal team to turn over all electronic devices used for business communications since 2021. Laptops, phones, cloud storage access, everything. The deadline is Wednesday, February 11. This is the part that tells you prosecutors aren't finished. They already have Melania's testimony. Now they want to check it against Ivanka's own communications. They're looking for deleted messages, conversations on encrypted apps, anything that confirms or contradicts what Melania said under oath. The order to surrender devices came after the passport seizure. That sequence matters. It means prosecutors believe there's more evidence to find. If the communications match the testimony, this case becomes almost impossible to defend. If they don't match, the defense gets ammunition. Friday, February 13, the device compliance deadline, is going to be the turning point of this entire prosecution. Within hours of the passport seizure, Ivanka's team put out a statement calling this politically motivated persecution. The quote, that statement was shared 2.4 million times. The hashtag was trending for 11 hours. Fundraising emails went out within 30 minutes. And then, the judge stepped in. She issued a partial gag order. Both sides are now prohibited from making public statements that could influence the jury pool. The order went into effect immediately. That means Ivanka can't keep calling this political. She can't fundraise directly off the case. She can't do the media tour. Her legal team filed an emergency appeal Sunday night. It was denied this morning. So here's where Ivanka Trump is right now. She can't travel internationally. She can't leave the Southern District of New York without court permission. She can't talk publicly about the case. Her location is being tracked by GPS. Last month, she was running international businesses. This week, she's wearing an ankle monitor. I need to explain why this matters beyond the obvious. If you own stock in anything connected to the Trump name, pay attention. Trump media stock dropped 12% on Friday. Trump Organization bond prices fell 8% by market close. Your portfolio might be affected through index funds, REITs, or banking sector investments without you even realizing it. But here's the bigger issue. This case establishes precedent. If you're ever involved in a legal matter where your spouse knows something about your finances or your adult children were present during a conversation, prosecutors can approach those people. They can offer immunity. They can ask them to testify. Spousal privilege means married couples generally can't be forced to testify against each other. But Melania wasn't forced. She cooperated voluntarily. And when it comes to stepchildren, there's no privilege protection at all. And if you've ever broken up financial transactions to avoid reporting requirements, if you've ever deliberately kept cash withdrawals under $10,000, you're watching your own methods being prosecuted right now. The IRS has increased structuring enforcement by 340% since 2020. This case is the highest profile example, but it's not the only one. Whatever happens here will influence how prosecutors across the country handle financial cases. If they win, they get more aggressive everywhere. If they lose, defense attorneys have a blueprint to follow. The rules are being written right now. Here's what happens next. Wednesday, February 11th, status conference. Ivanka's team argues for modified travel restrictions. The judge rules on the defense motions challenging the passport seizure, the gag order, and the device surrender timeline. Thursday, February 12th, the grand jury meets again. Additional charges are possible. The current indictment might not be the final version. Friday, February 13th, device compliance deadline. Whatever is on those laptops and phones becomes evidence. Forensic experts will find deleted messages. Prosecutors will know if encrypted apps were used. The case gets stronger or weaker based on what they find. Monday, February 16th, expected prosecution response to defense motions. The full transcript of Melania's testimony hasn't been released. The defense witness list hasn't been disclosed. Any cooperation agreements with other individuals in the investigation remain sealed. So here's where we stand tonight. Ivanka Trump, passport seized. $15 million bail. GPS monitoring. Gag order in effect. Melania Trump, testimony complete. No charges filed against her. Electronic devices, due Wednesday. Trial date, not yet set. Additional charges possible. The defense has 4 days to surrender those devices. 4 days to fight the gag order. 4 days before the grand jury might expand the indictment. Prosecutors have what they need to move forward, and they are not waiting. This case has moved faster in 5 days than some cases move in 5 months. That's not an accident. When you seize someone's passport at dawn, you're sending a message. We are serious. They are serious. On the surface, this is about a former White House advisor facing federal financial charges. But Melania's role is the story underneath the story. Why she cooperated. What she actually said. Whether her testimony holds up. The device surrender will tell us whether prosecutors can corroborate her testimony with hard evidence or whether they're relying on words alone. The judge's tone on Wednesday will signal where this is heading. Cases like this have fallen apart before. High-profile targets. Political pressure. Aggressive prosecution that couldn't close. This case might be different. The documentation is unusual. The witness is unprecedented. But we're still in the early chapters. The clock is running. Wednesday is coming. And whatever is on those devices will determine what happens next. That does it for us tonight. We will see you again tomorrow.